Hello, everyone. I'm here to provide a bit more context about the legal environment that led to the development and passage of the interim NIL policy across the three divisions. I know each division worked hard over the past months to develop a series of proposals to deal with name, image, and likeness. And you may still wonder what changed that caused a shift in strategy and philosophy from those divisional proposals to the interim NIL policy. And there really are a few reasons for that. One was the need to deal with the changing state law environment. We had and continue to have a number of states that pass their own unique NIL laws. And yet the association's commitment was that name, image, and likeness would be available to all student athletes. And so we had to develop a policy that would accommodate those student athletes in states without NIL laws with those student athletes that and institutions that were going to have commitments via that state law to make sure that they were in compliance. The second thing that changed was the release of the Supreme Court's decision in Alston. Now, Alston is a Division I antitrust case, but it has broad implications across the three divisions because of the fact that it is a Supreme Court decision dealing with the way that the association governs. And what we saw from that opinion, a unanimous opinion, was that the association has less deference in prescribing rules that are restrictive to student athletes. Now, all of that is done in the context of maintaining our commitment to non-employment status by students and to not reverting to a pay-for-play environment, or that institutional choices should be made by which NIL package is the best. So we are maintaining those principles without creating a broad set of restrictions that, at least for this point in time, we think the interim policy is a better response to the Supreme Court decision and to Alston, but still allowing for NIL to go forward. So what does this mean going forward? It means that we'll be operating in a decentralized approach more than what you're used to with respect to whether an NIL transaction violates rules. We have now committed that if it isn't a pay-for-play or a recruiting inducement type of situation, that the institution is in the best position to know whether the NIL activity complies with the state law and is also consistent with their own policies about name, image, and likeness. And so that is expected to continue across the three divisions. We hope Congress will act at a point in time to give us the construct of more regulation around name, image, and likeness, appropriate regulation that Congress acts on, or that we have developed a better set of data and information that might allow the association to move forward with additional rulemaking at a later point in time. I hope this information has been helpful. Thank you.